Hello, this is attorney Vijay Bhagwati from Bhagwati & Associates, PLLC. I would want to take this opportunity today to cover a topic relating to Comprehensive Immigration Reforms Bill of 2013. This is more so because we have been receiving multiple calls at our offices both at New York and New Jersey asking about as to what Comprehensive Immigration Reforms Bill is. For understanding of all, Comprehensive Immigration Reforms Bill is a systematic overhaul of a country's immigration system with a stated objective to introduce checks and balances into immigration system to make it fair for everybody. Now, a lot of immigration experts and other professionals who are conducting research on immigration for quite a while have come out with the conclusion that there are approximately 12 million undocumented workers living in the United States at this point in time. Now, it is not hard to believe as to how difficult it is to deport such a large population of undocumented workers. It is thus that with an objective to make sure that the current situation in immigration law is handled with more fairness, the Gang of Eight, that is four from Republican side and four senators from Democrat side, were asked to draft a bill. And while they have drafted the bill, they have introduced certain provisions relating to undocumented workers, and which includes the following four factors, which if are complied with, the undocumented worker can immediately get a status of registered provisional and would not have a fear to be deported from the country. And these four factors are that the undocumented worker must have visited the country, that is the United States, prior to December 31st, 2011. Number two, he must continue to hold a job. Number three, he must not have committed any felony. Number four, he must have paid taxes. And if he has done so, he is to pay a fine of $500. And then he can file for the registered provisional status. Initial status would be granted for a period of 6 years. Once the 6 years have been completed, he is eligible to file a renewal. Now this renewal will be for another 4 years. So in total, the status would be for 10 years, but when he is pursuing his renewal status after 6 years, he must make sure that he has not committed any felony. He again continues to hold the job. He continues to pay taxes, and he has to pay another $500 fine. That is called as a penalty. This would give him another 4-year status as a registered provisional. Now, once the 10 years are complete, and if he has again maintained to keep the same status while he for the first time went in for registered provisional status, and after 6 years for registered provisional renewal status, he can then file for his green card. Meaning that after 10 years of his paying taxes, of his continuing to hold job, of his continuing to be free from any criminal felony, of his continuing to pay taxes, he can then, after 10 years, file for green card. After 3 years of his receiving a green card, he can then apply for citizenship. So in total, it will need 13 years from the day he got his first registered provisional status for him to see a path to citizenship. In addition to undocumented workers, then there's another category of dreamers and agricultural workers who will see a quicker path to the green card and citizenship. The dreamers are those eligible applicants who visited this country before the age of 16. They have graduated from the school. They have been here in the United States for 5 years. And if they've complied with these three things, then they can apply for a green card and immediately for a citizenship, provided they have either completed 2 years of college or they have served 2 years in a military service. Agriculture workers likewise would see a quicker path to a green card and citizenship, but not as quick as is provided for dreamers. The proposed comprehensive immigration reform bill also provides for moving the family base to a category into immediate alien relative classification, which would provide visas immediately to spouses and children of legal permanent residents. Now, this also provides for US citizen parents to file petitions for their married sons and daughters until the age of 31. In addition, it also proposes to bring back visas. Now, this bill also talks and introduces several important provisions for H-1B classification. Since it's a very large and delicate topic, and which we would not be able to cover in this segment, I have decided to specifically talk about H-1B reforms separately in another segment, which we would introduce in a week to 10 days time. However, I would like to briefly touch upon a few important aspects that have been proposed for H-1B classification. First of all, the bill proposes to increase the H-1B cap from 65,000 to 110,000 and to ultimately 180,000. It also increases the fee for those employers whose 30% of the force is H-1B employees, and those employers who have 75% or more of their employees as H-1B would be banned or would be restricted from filing H-1B if they have reached the limit of 75% of their total workforce as H-1B employees. This would reduce to 65% and ultimately to 50% by the year 2016. In addition, the H-1B employers would also be required to conduct the recruitment process as is currently done in the perm cases. They would have to satisfy the requirement to prove to the service, that is the United States Citizenship and Immigration Services, that they failed to find a suitable worker to fulfill that job category from US citizen pool. In addition, there is a benefit that is provided for the derivatives of the H-1B holders, meaning the H-4s can apply for employment authorization document, which is currently available to L2. Those are the derivatives of the L1A category or L1B categories, meaning that the spouses and children of H-1B who are there on H-4, if they are eligible, could then apply for employment authorization document, meaning once they receive that, they can work. They would not be required to file for H-1B or be eligible for H-1B category. The bill also introduces a new category called W visa for low-skilled guest workers. This would start in the year 2015 and would be capped at 20,000. This cap would increase to 75,000 by the year 2019. Immigrants can apply for W visa in their home countries at US consulates or embassies. Once approved, they can live in this country in 3-year renewable terms with their family members. They would have to be continually employed. If they remain unemployed for 60 days or more, they must leave the country. The employers would be obligated to pay them minimum of prevailing wages as set by Department of Labor. And they cannot be employed in metropolitan areas where the unemployment is more than 8.5% unless there are certain exemptions set by the Secretary of Homeland Security. In addition, the employers would be restricted from firing any US worker within 90 days either prior or after hiring such guest workers. The bill also proposes to remove the one-year deadline for filing the asylum cases. This would mean that all those applicants who did not get to file their asylum applications within 1 year of their entry into the United States as illegal aliens would then be able to reopen their cases. Last but not the least, this bill completely does away with diversity visas, meaning the diversity visa category will be completely eliminated by the year 2015. This category was introduced to help all those countries which has the low rate of immigration into the United States. This visa category will now be replaced by the merit-based category, which would depend on three factors. One is the family ties, the work history in the United States, and strong skills in the work field. If these three are fulfilled, the person would be eligible to apply for a merit-based category. As I said, diversity visa category would then be eliminated by the year 2015. This is all proposal. All of you must make specific note that the segment that I'm covering about is the different important factors of immigration reforms bill. This has still not become a law. This would be introduced into the House once it is passed by the required majority. It would be tabled to the President, and once President signs, it will become an act. Until then, this is just a proposal. So the proposal is to eliminate diversity visa by the year 2015. Initially, the merit-based category, which will replace diversity visa, would be set at 120,000, which would increase to 250,000. Later, it would increase at the rate of 5% each year. So, as you've seen, that I've covered mostly very important provisions that have been introduced into this comprehensive immigration reforms bill for a general understanding of all. We can understand there are specific legal language that has been introduced, and when it is published in the news items or you see on TV, most of people would not understand what it actually means, and thus I did take this time to make it and put it in a very simplified manner so that everybody understand what this bill brings for everybody. In the end, this would be my strong recommendation for all those aliens who are considered as undocumented to prepare. Now is the time to prepare to get the benefit out of this bill if it becomes an act. What all the concerned must do: first of all, you must make sure that you are not subject to any crime, meaning you should not have committed any felony. You must not have any criminal history. You must be continually employed from day one. You must have paid the taxes. Now, if you have not paid taxes, we would recommend you to contact the certified public accountant, get his advice, and pay all the back taxes. Number 4, you must practice to learn English and civics. As you may know, this is one of the requirements when you go for the citizenship test. And number 5, whatever penalties are due, you must be able to pay that. If you comply with all these grounds, you would be eligible to pick up the benefit of the bill if it becomes an act, and you can see the path to a green card and a citizenship. Thank you, and good luck to everybody.